Are you at the end of your marriage, looking for an easy way out, but you've heard horror stories? You're afraid of the cost, you're afraid of the fighting, you're afraid of crazy attorneys running up the cost of your divorce? We've designed a new process to get a divorce. It's called the flat fee divorce. It is streamlined and it is intended to keep people out of the fighting, out of the courts, out of the expensive, destructive litigation process. If you're not interested in fighting, if you are ready to negotiate, to compromise, and ready to divide your assets reasonably in half, if you're not going to fight about the children, and you and your spouse are roughly on the same page about what should happen, the streamlined flat fee divorce may be the right approach for you. Let me tell you how it works. You start the process with a screening process. You fill out a form and you may or may not be admitted into the process. If you are fighting, if you're dealing with mental health issues, if there are overly complicated aspects to your divorce that need more serious lawyering, then you're not good for this process. If you are fighting, if you're dealing with mental health issues, if there are overly complicated aspects to your divorce that need more serious lawyering, then you're not good for this process. If you're admitted into the process, most likely you will come out of the process with a flat fee divorce, which controls the cost. It starts with a meeting. After you fill out the form, you meet with the attorney. It's a working session. During that session, you'll complete the initial pleadings for a divorce, whether it's a complaint or the answer to the complaint and a counter-complaint. All of the discovery requests, interrogatories, requests for production of documents, all of those are completed during this working session, along with a long-form financial statement. If there are children and custody issues, some of those cases are allowed into this streamlined process. You will complete a parenting plan. We will work out child support guidelines. All of the initial pleadings to get you through a divorce are completed during your first working session. What happens after that is everything is filed with the court, and the discovery is served on the other side. That's a request for information. Interrogatories are written questions, requests for production of documents, where we're asking your spouse, your partner, to provide all of the documents necessary to do an analysis how we're going to divide the assets, identifying the assets, and so forth. Once that's done, the session is completed and your case is filed with the court. The next thing that happens is a scheduling conference is scheduled by the court, and you get your dance card. The court is going to set in the trial date, going to set in various hearings that happen along the way. And the idea in this streamlined process is to skip all of that, get into mediation, and get both parties to a place where you're going to have an uncontested divorce. In the mediation session, preparing for the mediation session involves looking at the documents that you've provided and the documents that your spouse provided. These documents typically include pay stubs, tax returns, bank statements, credit cards. If there are child care costs, the documents that support all of that. These documents are reviewed and a reasonable compromise is looked at. The long-form financial statement identifies all of the assets. And there are discussions when preparing for mediation. How are we going to divide the assets? What's going to happen with the marital home? Are we going to keep it? Are children going to live in it? Are you going to share the home? If it's going to be sold, how it's going to be sold? What's going to happen to the proceeds? How is the house going to be paid for between now and the point of sale? All of these issues are worked out, and then the mediation session will be court ordered. It's 2 sessions, 2 hours each. The cost of the mediator is separate from the flat fee divorce, and the process is separate. It's part of the court process. But out of that session should come an agreement. And the agreement is reduced to writing into what's called a marital separation agreement. Once that agreement is signed, The next phase of the streamlined flat fee divorce process takes place. We file an answer and we request a hearing. If there are children, a child support guideline worksheet is prepared, child support is established, the parenting plan is signed off by the parties and filed with the court. Within 6 to 7 weeks, you should get your date and you should be finished with your divorce. The flat fee divorce is, if there are no children, is $5,000. If there are children, it's $7,500. Those fees do not include the court filing fee, which is, depending on what jurisdiction you're in, is less than $200. You should be able to get out of your marriage, if you're reasonable, with a total of less than $6,000. If there are children, it will be less than $8,000. There are some cases that are not right for a flat fee divorce. If you're dealing with mental health issues, if your spouse is a narcissist or has a personality disorder, for example, they're not going to be reasonable, and this process will be frustrated and fail. If there is significant domestic violence or bullying, or if you have a spouse who is extremely angry, more interested in fighting and hurting you than in working together toward a compromise and a reasonable conclusion to your marriage, this process is not for you. But if it is, give us a call. Alice Paré from Paré Associates, and I hope I can get you through a peaceful, streamlined divorce.